everyone. Illegally obtained evidence can now be used in court. The Supreme Court came to this ruling with a 5-3 decision. Local News 8 reporter Taja Davis sat down with local law enforcement today to talk about this a little. Taja?
Carol, let me break this down for you. This ruling was based on a case called Utah v. Streif. There was an anonymous tip of drug activity in a house. Police confronted a man, checked his records, searched him without a warrant, and found a small bag of methamphetamine. The stop was deemed unlawful, but now the Supreme Court is saying the evidence found in that illegal search can be used in court.
An anonymous tip, which is what was used or which is what they had here, does not, by itself, is not reasonable suspicion.
The Supreme Court made a decision that evidence found during unlawful contact can be shown to a jury.
The thing in this case, I think, that was in question was the reason the person was contacted in the first place.
The only thing the court's answering is, should that evidence be kicked out because of it?
Justice Sonia Sotomayor fears allowing evidence to be used from an illegal search will expand police power. She stated, "This case tells everyone, white and black, guilty and innocent, that an officer can verify legal status and invade at any time." But many states, like Idaho, have their own constitutions and where they give citizens an extra layer of protection under the Fourth Amendment.
Each state is allowed to apply their own analysis and give a citizen greater protection than the Fourth Amendment does.
People may be worried police now have the power to stop anyone at any time, even if you've done nothing wrong. But in Bonneville County, that's not how police stops operate, and they're not going to start that way now.
So I don't see this changing anything that the police are doing.
I don't think it gives us the ability to just willy-nilly stop anybody for no reason at all. I think we're still going to do business the same way. We don't train to do unlawful contacts. We train to do things within the bounds of the law, and that's our job.
Now, the state of Idaho is going to have to deal with this question itself and put its interpretation into the state's constitution. If you would like to read the full case file, it is on our website, localnews8.com. In the studio tonight, I'm Taja Davis.
All right, thank you. The Fourth Amendment does not talk about dismissing illegally obtained evidence. That is the creation of the Supreme Court. Also, it was ruled today that police can conduct breathalyzer tests without a warrant. Police cannot, however, conduct a blood alcohol test without a warrant.